Let me tell you about a case that came before my bench. A case that reminded me why sunlight is fairness, why access is infrastructure, and why borrowed money is never borrowed authority. Victoria Ashford walked into my courtroom with her phone in her hand and a lunch reservation on her mind, 23 years old. When I asked her to put the phone away and address the charges, she responded as if this were customer service. Her attorney tried to make it simple. Pay the fines, resolve it today, move on. But this court is not a payment portal. The charges were clear. Docket 24-10847. Commonwealth versus Victoria Marie Ashford. Unauthorized use of a disabled and van-accessible parking space. Destruction of a citation. Failure to appear on 3 summons notices. Contempt for prior no-show. Citation issued by Officer Leah Romano at 9:42 inches the morning on a Wednesday. 3 certified notices had been mailed to her residence. All 3 signed for October 2nd, signed for October 4th, October 16th, signed for October 18th, October 30th, signed for November 1st. 3 notices over 4 weeks. When I asked if she received them, she said her assistant handles mail. When I pressed, she said, I guess that's not oversight, that's pattern. There was context, too. 14 months earlier, she'd blocked a loading zone at Brown University for over an hour during a catering delivery, told the attendant her family donated the library. Not a criminal matter, but it showed me something about how she moved through the world. So I asked her to walk me through Wednesday morning. She parked in front of a pharmacy on Hope Street, said she was inside maybe 10 minutes. When she came out, there was a ticket on her windshield. She tore it up, didn't think it was valid. When I pointed out she'd parked in a disabled and van-accessible space, she said no one was using it. No harm, no foul. But harm isn't just collision, it's denial. Let me read you one line from a written statement submitted by Laura Bennett, a mother who arrived at that pharmacy at 9:51 that morning. The ramp could not lower. My daughter missed her therapy window. Miss Ashford waved her hand, said that wasn't her fault. Mrs. Bennett could have parked somewhere else. Her attorney objected, said we were introducing emotional context that wasn't material to the citation, but access denial is the material fact. Mrs. Bennett's daughter uses a wheelchair. She couldn't access the building because Victoria Ashford blocked the only van-accessible space. That's not emotional. That's factual harm. I had Officer Romano read her narrative into the record. At 9:42, she observed a silver luxury sedan parked in a van-accessible space. Proper signage, diagonal access striping, no disabled placard or license plate. She issued the citation, placed it on the windshield. At 9:53, she watched the driver exit the pharmacy, remove the citation, tear it in half, and discard it on the sidewalk. When Officer Romano approached and explained the violation, Miss Ashford said, "This is ridiculous. Do you know who I am?" And she said, "Write another one. My family funds this city." I asked Officer Romano if she perceived that as intimidation. She said yes. Miss Ashford claimed it was sarcasm, so we played the body cam audio. Her voice came through, clipped and dismissive. "My family funds this city." I let the silence hold. Her father is Marcus Ashford, founder of Ashford Innovations. The family has made significant philanthropic contributions to Providence, including municipal projects. When I asked what she meant by "my family funds this city," she said they support the community. I asked Officer Romano how she interpreted it. She said as leverage, Your Honor, an implied consequence for writing the citation. Sarcasm doesn't lower ramps. Then I learned something else. My clerk confirmed there had been contacts to the court regarding this case before the hearing. 2 incoming calls and 1 voicemail, all from a number registered to Ashford Innovations Donor Relations. First call at 10:18 inches the morning, second call at 10:47, voicemail at 11:12, an email from a civic philanthropy liaison at 10:52 referencing a quiet resolution. The email read, "We understand a citation was issued this morning to a member of the Ashford family. Given the family's longstanding support of municipal initiatives, we'd like to discuss options for resolving this matter quietly and efficiently before it proceeds." Her attorney objected, said his client wasn't responsible for communications from her family's foundation. I overruled him. Pressures on process are relevant when logged. I wasn't accusing anyone of criminal conduct. I was documenting facts. Miss Ashford said she didn't ask them to call. Maybe not, but someone thought it would help. Let me lay out the timeline. Citation issued at 9:42. First call from Ashford, innovations at 10:18. That's 36 minutes. Email sent at 10:52. Someone moved fast. I asked if Laura Bennett was available to give a statement. She was. By phone. Her voice was steady but strained. Her daughter has cerebral palsy. She receives physical therapy twice a week. Wednesday was a critical session. They arrived at the pharmacy at 9:51 to pick up medication before therapy. The van accessible space was blocked. She couldn't lower the side entry ramp. By the time they found another spot and got inside, they'd missed the first 20 minutes of therapy. The therapist had to reschedule. Access is infrastructure. It's not optional. Miss Ashford muttered something. I asked her to say it clearly. She said it was 10 minutes. 10 minutes is a therapy window, Miss Ashford. Her attorney tried again. Asked if we could handle the remainder of the hearing off the public calendar, given the Ashford family's role in municipal philanthropy. Said public proceedings could create unnecessary complications for ongoing civic partnerships. Sunlight is fairness. We stayed on the record. I asked Victoria Ashford 3 yes or no questions. Did you park in a disabled and van accessible space without authorization? Yes. Did you tear up the citation and discard it? Yes. Did you ignore 3 summons notices? She hesitated, said she didn't think they were serious. I asked again, did you ignore them? Yes. Then her voice rose. She said this was absurd, that her family has donated millions to the city, that they fund programs, support infrastructure, that we wouldn't have half our budget without them. I reminded her, donations don't purchase exemptions. She said they should purchase some respect. Asked if I knew how much her father contributes to municipal operations. Then she said it, your salary is paid by taxpayers like us. Her attorney stood quickly to object, but she wasn't finished. I own you. The words hung in the air. 5 seconds. 7, 10, 12. That was the moment money ran out of jurisdiction. No one moved. No one spoke. Miss Ashford stared at the bench, realizing too late what she'd said. Her attorney's face went pale. I spoke quietly. Miss Ashford, you own nothing in this courtroom. Not the process, not the outcome, not me. The evidence supported all 4 charges. Officer Romano's narrative was credible and corroborated by body cam audio, fixed camera, lot photographs, the torn citation, 3 delivery confirmed summons notices, and the timeline of foundation calls and emails. She parked in a disabled and van accessible space, denying critical access to a family with mobility needs. She destroyed a citation. She ignored 3 summons notices over 4 weeks. She invoked her family's financial contributions in a manner that Officer Romano reasonably perceived as intimidation. This court does not weigh cases based on wealth, donations, or family foundation contacts. Borrowed money is not borrowed authority. Your family's philanthropy does not grant you ownership of public process. Your status does not erase harm. Access is not for auction. I noted the prior advisory from campus parking. That was instructional, not punitive. She'd been told once that loading zones matter. She chose not to internalize that lesson. Consequences teach what privilege hid. The base fines total $750. Unauthorized use of a disabled bay, $300. Contempt for failure to appear, $300. Administrative fees, $150. But I wasn't finished. I stayed a portion of that total, $400, contingent on her full and timely completion of a restorative accountability plan. If she completed it, that portion would be remitted. If she didn't, it would be reinstated and she'd pay the full amount. The plan required 5 things. First, written apologies to Officer Leah Romano and Laura Bennett, not form letters drafted by the family's PR team. Real apologies that named what she did and what she learned. Delivered in person if both agreed to meet. If either declined, mailed with court confirmation of receipt. Second, 150 hours of community service split between 2 organizations, 75 hours at the Rhode Island Food Bank. 75 hours at the Mobility Access Coalition assisting with accessibility audits and community outreach. Both organizations would submit attendance logs to the court. No press releases, no photo opportunities. Third, she would write and record 2 public service announcements for school distribution, both court vetted, on access equity and the difference between charity and entitlement. Fourth, she would complete a donor influence ethics module covering the separation between philanthropy and public process. Certification of completion would be filed with the court. Fifth, she would submit a 900-word written reflection on the topic money versus authority, not slogans drafted by a communications team. Plain truth in her own words. Mercy isn't a discount. It's a contract. Additionally, I made recommendations on the record to the Municipal Court Administration and the Office of the Mayor. 1. Establish an ex parte influence log for all cases. Any off-record communication attempts, including from donors or their representatives, would be documented and published weekly. 2. Create a donor contact firewall with required disclosure. Any case involving a defendant whose family has made significant municipal donations must be flagged, and any contact from donor-related entities must be disclosed immediately. 3. Implement mandatory supervisor, cosign, and recusal protocols. If any court staff member is contacted by a donor representative regarding a pending case, that staff member must recuse or obtain supervisor authorization. 4. Develop disabled bay, tow first escalation. Unauthorized vehicles in van-accessible spaces should trigger immediate tow protocols to minimize access denial. 5. Create a municipal PSA series on access rights featuring real testimony from families who rely on accessible infrastructure. 6. Launch a clerk hotline for influence attempts. Any effort to leverage donations, connections, or wealth can be reported anonymously. Every report will be investigated. This model protects the system. Over the next 12 weeks, Victoria Ashford completed the plan piece by piece. Week 1, she drafted the apology. The court rejected it. Too polished, clearly written by someone else. She tried again in her own words. Better. Officer Romano agreed to meet her at a coffee shop near the courthouse. The conversation was brief, uncomfortable, and necessary. Romano told her, "When you said your family funds the city, you made me feel like my job was for sale. It's not." Laura Bennett accepted the written apology but declined the in-person meeting. She emailed the court. She named what she took from us. That's enough. Weeks 2 through 10, Victoria logged 150 hours across both organizations. At the food bank, she sorted donations, stocked shelves, and assisted with distribution logistics. No press, no cameras. One volunteer coordinator told her, "Service isn't about who sees you do it." At the Mobility Access Coalition, she assisted with accessibility audits at local businesses, learned how ramp angles and door widths are calculated, and scheduled community outreach visits. One wheelchair user told her, "Access isn't a favor, it's a right." Week 9, she recorded the PSAs. The first drafts were too corporate, too scripted. The court sent them back. She recorded them again, plainly, no branding, no family mentions, just her voice and the truth. The second versions passed. The donor influence ethics module took another 3 weeks. She completed it without complaint. The ledger was simple. 150 hours logged, 2 PSAs approved, 1 firewall established, 1 entitlement interrupted. Officer Romano told the court she showed up every time. That matters. 12 weeks after the initial hearing, Victoria returned to court. This time she was alone. No counsel, no family representative, no entourage. I reviewed the submitted documents, the apologies, the service logs, the PSA recordings, the module certificate, the written reflection. Miss Ashford, I've read your reflection. I want to hear you summarize it in your own words. No script. She stood. I thought money meant access. I thought because my family donated to programs, I could park wherever I wanted, ignore tickets, skip court dates. I thought we fund this meant I own this. I didn't understand that public office isn't for sale, it's for service. She paused. When I told you I own you, I was wrong. I don't own anything except my own choices. Money can build a library, but it can't buy my way out of blocking someone's ramp. I blocked Miss Bennett's daughter from accessing therapy. I told Officer Romano her job was for sale. Both of those things were wrong. What did you learn from Officer Romano? That public servants aren't employees of my family's foundation. They serve the community, not individual donors. When I used our donations as leverage, I tried to corrupt that. What did you learn from the Mobility Access Coalition? That accessible parking isn't about convenience. It's about math. Ramp angles, clearance widths, transfer space. When I blocked that space for 10 minutes, I didn't just delay someone. I denied them access to medication. Time is infrastructure. She stopped trying to own the system and started learning to respect it. I signed a form. I remitted $350 of the stayed portion. She still owed $400 total. She would pay it in installments over 6 months. The court would monitor compliance. As a reminder, Miss Ashford, access is not for auction. She thanked me. I told her not to thank me. Thank the people who taught her what I couldn't. 5 months later, the policies took root. The court published its first ex parte influence log. 3 donor-related contact attempts were logged in the first month, all handled transparently per the new firewall protocol. Court staff reported feeling protected by the disclosure requirements. The donor contact firewall was adopted across all municipal courts. Cases involving significant donor families were flagged automatically. Supervisor co-signed protocols were implemented without incident. Disabled Beto first escalation was adopted citywide. Average clearance time for unauthorized vehicles dropped by 47%. Complaints from wheelchair users decreased significantly. The municipal PSA series launched, featuring testimony from families who rely on accessible infrastructure. Victoria's recordings were included, distributed to 31 schools. They weren't viral. They weren't celebrated. But they were used, and that was enough. One parent emailed the court, "My son watched the PSA about van accessible spaces and asked why people block them. We had a real conversation about access being a right, not a privilege. Thank you." On a quiet Friday afternoon, I finished my last case of the week. Before leaving, I wrote a single principle on a note card and pinned it to the bulletin board behind my bench. Public office is not for sale. It is for service. I thought of Victoria Ashford, of Officer Romano standing in a parking lot with someone's wealth thrown in her face, of Laura Bennett's daughter waiting in the van while therapy minutes ticked away. I turned off the light and locked the door.